Hello and welcome to the channel. It is no secret that former head of state General Sani Abacha almost bled Nigeria with his thievery. Over $5 billion of the late Abacha's loot has in this report been mismanaged by the subsequent Obasanjo Yaradua Jonathan and Buhari's government. But a court has now compelled all four ex-presidents to give account of the said money. Subscribe, like, share, and comment. Thank you. Court orders Obasanjo Yaradua Jonathan and Buhari's government to account for $5 billion Abacha loot. The Federal High Court, sitting in Abuja in a landmark judgment, has ordered the disclosure of the spending details of about $5 billion Abacha loot by the governments of former President Olusegun Obasanjo, Umaru Musa Yaradua, Goodluck Jonathan, and Muhammadu Buhari. The court ordered the government of President Bola Tinubu to disclose the exact amount of money stolen by General Sani Abacha from Nigeria, and the total amount of Abacha loot recovered, and all agreements signed on same by the governments of former Presidents Obasanjo, Yaradua, Jonathan, and Buhari. The judgment was delivered last week by Justice James Kolawole Omotosho, following a Freedom of Information suit number FHC ABJ CS 407-2020. Brought by the Social Economic Rights and Accountability Project, (SERAP). In his judgment, Justice Omotosho held that in the final analysis, the application by SERAP is meritorious, and the federal government, through the Ministry of Finance, is hereby ordered to furnish SERAP with the full spending details of about $5 billion Abacha loot within 7 days of this judgment. Justice Omotosho ordered the government to disclose details of the projects executed with the Abacha loot, locations of any such projects, and the names of companies and contractors that carried or carrying out the projects since the return of democracy in 1999 till date. Justice Omotosho also ordered the government to disclose details of specific roles played by the World Bank and other partners in the execution of any projects funded with Abacha loot under the governments of former presidents Obasanjo, Yaradua, Jonathan, and Buhari. Justice Omotosho also stated that the excuse by the Minister of Finance is that the ministry has searched its records and the details of the exact public funds stolen by Abacha and how the funds have been spent are not held by the ministry. The excuse has no leg to stand in view of Section 7 of the Freedom of Information Act. Justice Omotosho dismissed all the objections raised by the federal government and upheld SERAP's arguments. Consequently, the court entered judgment in favor of SERAP against the federal government. Justice Omotosho's judgment, dated 3rd July 2023, read in part: the failure of the Minister of Finance to write to SERAP informing it of where the said information exists or to transfer the request to public office who has custody of such information is fatal to their case under Section 5 of the Freedom of Information Act. The ministry cannot use a blanket statement that it was not in possession of the said records of about $5 billion Abacha loot sought by SERAP. The government failed to provide details of the projects executed with the money. It also failed to provide locations of the projects and the names of the companies and contractors that carried out or are carrying out the projects funded with the money. I hold that by the clear wordings of Section 7 of the Freedom of Information Act 2011, access to information about spending details of $5 billion Abacha loot was denied SERAP by the federal government. The federal government had filed a 14-paragraph counter-affidavit deposed to by Abba Sunday, litigation officer in the Office of the Attorney General of the Federation, argued that SERAP's suit is frivolous as it has not shown that the government denied it the information it seeks. The federal government has also stated that SERAP has not established sufficient interest in its application. The government urged the court to dismiss the suit. For the sake of emphasis, possession of local standing has been the bane of the citizens' advocates in the public interest litigation, to query transparency and accountability in governance in Nigeria. In a democratic dispensation, such as in Nigeria, the citizens have been proclaimed the owners of sovereignty and mandates that place leaders in the saddle. The requirement is a serious fraction of the citizens' inalienable rights to ventilate their grievances against poor governance vis-a-vis expenditure of public funds generated from their taxes. The sacrosanct provision of Section 1, 2 of the Freedom of Information Act, which has ostracized this disturbing requirement, has admirably remedied the harmful mischief appertinent to it. Clearly, Section 1 gives a person the right to access any information from any public institution in Nigeria. CIRAP is an organization registered in Nigeria and thus a juristic person. As a juristic person, CIRAP need not show any specific interest in the spending details of about $5 billion Abacha loans to be entitled to the same. Subscribe, like, share, comment, and please turn the notification bell on. Thank you. I therefore hold that CIRAP is entitled to the information on the spending details of about $5 billion Abacha loans and need not show any special interest in the information sought. The provision of Section 4 of the Freedom of Information Act is quite clear and mandates that public institution or public officer, such as the Minister of Finance and the Attorney General of the Federation and Minister of Justice, must make available the information requested within 7 days of the request. In the letter dated 8 July 2023, sent to President Tinubu on the judgment and signed by CIRAP Deputy Director Kolawole Oluwadare, the organization said, "We urge you to demonstrate your expressed commitment to the rule of law by immediately obeying and respecting the judgment of the court." CIRAP's later read in part, "We urge you to direct the Ministry of Finance and the Office of the Attorney General of the Federation to immediately compile and release the spending details of recovered Abacha loans as ordered by the court. The immediate enforcement and implementation of the judgment by your government will be a victory for the rule of law, transparency, and accountability in the governance processes and management of public resources, including the $5 billion Abacha loans. By immediately complying with the judgment, your government will be demonstrating to Nigerians that it is different from the Buhari government, which persistently and brazenly defied the country's judiciary, and sending a powerful message to politicians and others that there will be no impunity for grand corruption." That's the news, guys. Thanks for listening. Until next time, bye.